Revolving light. Imagine a company has been liquidated. Assets have been sold, creditors have been paid, shareholders have received distributions. The company liquidator has transferred all unclaimed amounts into the company liquidation dividend account. Everything appears complete. But then, after several years, a creditor suddenly appears. A shareholder discovers old records. A legal heir finds evidence of entitlement. A forgotten claimant realizes that money belonging to him is lying somewhere in the system. Can that money still be recovered? Has the right been permanently lost? Does the government become the owner of the funds? Or does the Companies Act continue to protect the rightful claimant even after liquidation is substantially over? The answer lies in one of the most important investor protection provisions under the Winding Up framework of the Companies Act 2013, a provision that ensures stakeholder rights do not disappear merely because time has passed. A provision that protects creditors, contributories, legal heirs, and investors from losing their lawful entitlements. Today we are decoding Section 353 of the Companies Act 2013, a provision every company secretary, chartered accountant, cost accountant, advocate, insolvency professional, director, investor, and corporate governance professional must understand. Welcome to Corporate and Securities Law Compass, navigating law with clarity. To understand Section 353 properly, we must first understand the broader framework created by Sections 350, 351, and 352. The Companies Act establishes a complete chain of protection for liquidation funds. Section 350 deals with deposit of liquidation monies into designated banking arrangements. Section 351 governs handling of certain liquidation funds and public accountability. Section 352 requires transfer of unpaid dividends and undistributed assets into the company liquidation dividend and undistributed assets account. The obvious question then arises: what happens after the transfer? What happens when a genuine claimant appears years later? Section 353 provides the answer. The legislative philosophy behind this provision is extremely important. The law recognizes that delays in claiming money do not necessarily extinguish ownership rights. Stakeholders may fail to claim amounts for numerous legitimate reasons. They may have changed residence, they may have lost records, they may have been unaware of liquidation proceedings. They may have become legal heirs after the death of an original shareholder or creditor. The legislature therefore created a recovery mechanism. This recovery mechanism protects fairness and investor confidence. Section 353 allows a person claiming entitlement to money transferred into the company liquidation dividend and undistributed assets account to apply for payment of the amount due to him. This provision effectively acts as a statutory safeguard against permanent loss of stakeholder rights. The importance of this provision cannot be overstated. Imagine a shareholder entitled to 10 lakh rupees from surplus assets after liquidation. Due to relocation abroad, the shareholder never receives communication from the liquidator. The amount remains unclaimed. The liquidator transfers it to the prescribed account in compliance with Section 352. Several years later, the shareholder discovers the entitlement. Without Section 353, recovery could become extremely difficult. The provision ensures that a lawful mechanism exists for reclaiming the money. Let us consider another practical illustration. A creditor was entitled to receive distribution during liquidation. Before claiming the amount, the creditor passed away. The legal heirs were unaware of the entitlement. Years later, while reviewing family documents, they discover the claim. Section 353 provides the pathway through which the rightful amount may be sought. This demonstrates the investor protection and stakeholder protection philosophy embedded within the Companies Act. An important legal principle underlying this provision is the distinction between custody and ownership. When money is transferred into the company liquidation dividend and undistributed assets account, ownership does not automatically shift to the government. The account functions as a protective repository. The beneficial owner remains the person legally entitled to receive the money. This distinction is critical for both examinations and practical corporate law understanding. Many students incorrectly assume that transfer to a government-controlled account results in forfeiture. That assumption is incorrect. The statutory framework is designed to preserve rights, not destroy them. From a governance perspective, Section 353 strengthens confidence in the corporate legal system. Investors know that their rights remain protected. Creditors know that delayed claims are not automatically extinguished. Legal heirs know that legitimate entitlements remain recoverable. The law thereby promotes trust in liquidation procedures. Now let us examine the procedural perspective. A claimant seeking payment must establish entitlement. Evidence becomes crucial. Identity documentation becomes important. Supporting records relating to the original claim may be required. Succession documents may become necessary in case of legal heirs. Corporate records, share certificates, proof of debt documents, or other supporting evidence may play an important role. This is where professional advisors become extremely valuable. Advocates assist in establishing legal entitlement. Company secretaries help verify corporate records. Chartered accountants assist in tracing financial evidence. Cost accountants may help reconstruct historical transactions where necessary. The recovery process, therefore, often involves multidisciplinary professional expertise. One hidden practical lesson from Section 353 is the importance of record preservation. Many stakeholders lose valuable rights simply because they fail to preserve documents. Corporate records, shareholder communications, dividend notices, and liquidation correspondence should never be ignored. Professionals conducting due diligence exercises should also pay attention to historical liquidation records. Potential entitlements sometimes remain undiscovered for years. From a secretarial compliance perspective, maintenance of accurate stakeholder databases becomes essential. The better the records maintained by the liquidator, the easier it becomes to identify rightful claimants in the future. Poor record keeping increases litigation risk. Poor documentation delays recovery. Poor communication often results in avoidable disputes. A common practical mistake occurs when stakeholders assume that unclaimed amounts have been permanently lost. Another mistake occurs when legal heirs fail to investigate historical corporate holdings. A third mistake occurs when professionals overlook liquidation related entitlements during estate planning or succession reviews. These seemingly minor oversights can have significant financial consequences. From a litigation perspective, disputes may arise regarding entitlement. Multiple claimants may emerge. Questions regarding succession may arise. Corporate records may require interpretation. Documentary evidence may become crucial. This is why accuracy in maintaining liquidation records is so important. Another interesting governance concept emerging from Section 353 is continuity of rights. Although the company may have ceased active operations, stakeholder rights continue to receive legal recognition. The law therefore extends protection beyond the operational life of the company itself. This reflects the broader philosophy of fairness embedded throughout the Companies Act 2013. Students preparing for CS Executive, CS Professional, CA, CMA, and law examinations should pay particular attention to this conceptual framework. The examination focus is often not merely on statutory language. The focus is frequently on understanding legislative intent. The legislative intent here is clear: protect stakeholder rights, preserve entitlements, facilitate recovery, promote fairness, strengthen investor confidence. The provision also connects with wider principles of fiduciary responsibility. A liquidator acts as a custodian of stakeholder interests. The transfer mechanism under Section 352 and the recovery mechanism under Section 353 together ensure that stakeholder money remains protected throughout the life cycle of liquidation. When viewed collectively, these provisions create a complete governance framework. Money is safeguarded. Unclaimed amounts are preserved. Recovery rights remain available. Stakeholder interests remain protected. This is exactly how modern corporate governance should function. From a practical compliance perspective, professionals should always verify whether unclaimed amounts were properly transferred. They should verify whether records were maintained. They should verify whether potential claimants have adequate access to information. They should verify whether stakeholder rights remain traceable. These checks form an important part of liquidation due diligence and governance review. For investors, this provision offers reassurance. For creditors, it provides protection. For legal heirs, it creates opportunity for recovery. For professionals, it creates responsibility. For regulators, it reinforces accountability. As we conclude, remember that Section 353 is far more than a procedural recovery provision. It is an investor protection mechanism. It is a stakeholder rights provision. It is a governance safeguard. It is a fairness-based legal remedy. Most importantly, it ensures that genuine claimants are not deprived of their lawful entitlements merely because money remained unclaimed during liquidation. For company secretaries, chartered accountants, cost accountants, advocates, insolvency professionals, directors, investors, and governance practitioners, understanding Section 353 is essential because true corporate governance does not end when assets are distributed. True corporate governance continues until every rightful stakeholder has a fair opportunity to recover what legally belongs to him. And that is why Section 353 occupies such a significant place within the winding up framework of the Companies Act 2013. Disclaimer: viewing this video or accessing the content on this channel are free and does not create any professional, advisory, or client relationship between the speaker and the viewer. The content is shared solely for general educational and informational purposes. The speaker is a member of the Institute of Company Secretaries of India (ICSI). However, the information provided in this video should not be construed as professional advice, consultancy, or opinion under any law or regulation. Viewers should not rely solely on the information provided in this video for making legal, financial, regulatory, or compliance decisions. Any person intending to rely upon or act on the information contained herein should independently verify the relevant provisions of law and, where appropriate, seek professional advice from a qualified professional. The speaker, the Institute of Company Secretaries of India (ICSI), and any organization or listed company with which the speaker may be associated shall not be liable for any direct or indirect loss, damage, or consequences arising from reliance on the information provided in this video or channel. The content shared on this channel is based solely on publicly available information, general legal provisions, and academic discussion of corporate and regulatory frameworks. The speaker confirms that no unpublished price-sensitive information (UPSI), confidential information, or proprietary information of any listed company or organization has been disclosed or discussed in any video or content on this channel. The views expressed in the videos are personal academic interpretations for educational purposes only and are not connected with or derived from any confidential information obtained through employment, professional engagement, or association with any listed company or organization. Nothing contained in this channel should be interpreted as market advice, investment advice, or insider information under the applicable provisions of securities laws, including the SEBI Prohibition of Insider Trading Regulations 2015. Viewers are advised that the information shared is purely for general educational awareness and should not be relied upon for investment decisions, trading decisions, or regulatory compliance without consulting appropriate professionals and official sources.